SJC-12027, Commonwealth versus Jones.
Good morning, Mr. Sultan. Hopefully your voice is stronger than mine.
Good morning, Mr. Chief Justice, and may it please the court.
Sorry.
It's fundamental to our system of criminal justice that every man or woman accused of a crime is entitled to a fair trial. Maurice Jones was accused of first-degree murder, convicted, and sentenced to life imprisonment without the possibility of parole, but he did not receive a fair trial. The evidence that he committed this crime was grossly insufficient, and the trial was infected with serious constitutional errors, including the Commonwealth's deliberate introduction and exploitation of evidence that Jones refused to participate in a show-up identification procedure, and the trial judge's refusal to require the Commonwealth to justify its peremptory challenge of a black juror, the fifth of 6 black jurors who had been found indifferent the Commonwealth had struck to that point. Let me start with for these reasons, I submit that under these unusual and compelling circumstances, the court must not allow this conviction to stand. Let me start with the sufficiency issue, if I may. The Commonwealth presented evidence that Jones was in the vicinity of the shooting, which occurred next to a public park on a sunny, warm spring afternoon when there were lots of people in the area. So his presence in and of itself proves nothing about the identity of the perpetrator.
There's some disagreement between you and the Commonwealth about how specifically accurate the CSLI is in terms of identifying exactly where somebody was. But I think we're putting that aside. There were witnesses. This is not disagreeing with your point about perpetrator, but do you disagree that there's plenty of evidence that he was actually very near the park at the time?
I don't disagree, Your Honor. There was plenty of evidence that he was in the area. There were 3 witnesses who knew him, who testified to seeing him in the area shortly after the shooting. None of those 3 witnesses saw him holding anything, saw him doing anything.
And did they see him running?
One of them saw him running, and one of them, Andrews, saw him running through the park. She said everyone was running, and he was running with everyone else through the park. 2 others, McLean and Baker, saw him walking by their houses in the vicinity shortly after the shooting. But none of those 3 people saw him doing anything or holding anything suspicious. Baker said he was holding his hand across his stomach like he was hurt. The others didn't see anything at all. None of them saw distinctive clothing. None of them mentioned this famous red and white T-shirt. But yes, there's plenty of evidence he was in the area, including the CSLI evidence, which I think the jury could certainly infer that he was in the area. But the Commonwealth's notion that he was in the precise location of the shooting at the time of the shooting is completely fanciful. I mean, there was no call between 3:59 and 4:09, and the shooting occurred at 4:04. So even if you assume that the CSLI evidence is precise, which it isn't, there was no evidence where he was at 4:04 at the time of the shooting. There was no call at that time. So they vastly overstate that evidence.
And the Platt, is that her name?
Yes, Your Honor.
The person that she saw,
Yes.
Was walking, she's leisurely, or she had somewhere, lackadaisical, I forget what
She
was the word.
testified that she saw somebody walking.
Was this after the shot?
Right after the shooting, someone walking away from her car. I think she described it as lackadaisically. She got a glimpse of that person through a shattered window. She did not see the front of that person.
But in other words, he wasn't running, that's all I'm trying to get.
No, he was not running, Your Honor.
Okay.
So that's what she claimed she saw. So certainly there's evidence of mere presence.
Didn't a couple of different witnesses see him holding not just his hand in front of his side, but also holding his pocket as if he had something heavy in it?
Well, Your Honor, this is where, as I indicated in my reply brief, the Commonwealth conflates evidence about Mr. Jones with evidence about somebody who was running holding his pocket. So there was evidence from 6 witnesses that somebody was running, and a number of those witnesses says he appeared to be holding something, and it was, some of them said it was heavy. Leela Jackson said she thought maybe it was a gun because it looked heavy. But Leela Jackson said the individual that she saw holding his pocket was not dark-skinned. And if you look at Exhibit 23, which is in the appendix, which is a photograph of Maurice Jones taken later that afternoon by the police, he's very dark-skinned. She said the person she saw was wearing a black hat with a white brim. Well, Jones was not wearing a black hat with a white brim when the police encountered him half an hour later.
Was he wearing
a
cargo
jacket.
pants? Was he wearing cargo pants and Chuck Taylors?
He was not wearing Chuck Taylor sneakers. And
They're distinctive shoes, right?
well, they are, and Ms. Platt, with all of her uncertainty, she said both in her statements at the hospital, her recorded statements, and she reiterated at trial, she was sure he was wearing Chuck Taylors because she had a pair of those Chuck Taylors with the white front and the white stripe down the side, and the photograph, which is Exhibit 26, of Mr. Jones's shoes taken when he was encountered by the police. He was wearing black Nikes with a red sole. They were not Chuck Taylors. So, I mean, the identification evidence is unbelievably weak. So to answer your question, Justice Budd, yes, there were witnesses who said they saw somebody running who appeared to be holding something heavy in his pocket, which perhaps you could infer was a gun, although I think that's a kind of a speculative leap. But there's no evidence that person was Mr. Jones. None of those people identified Mr. Jones or identified anything distinctive about that individual, which would make that individual be Mr. Jones. And not just Leela Jackson, but Leela Jackson's sister, Lenora Woodson, also said the person was not dark-skinned. So you have two of those witnesses specifically said the person they saw running, holding his pocket, was not dark-skinned. That could not have been Maurice Jones. So they have mere presence. They don't have mere presence of Mr. Jones running with holding his pocket.
So there were two
that wasn't
people.
Mr. Jones.
There are 2 people with cargo pants. in the
Cargo
area?
pants. Mr. Jones did have cargo pants when he was encountered by the police.
Are these pants or shorts?
Well,
Shorts.
the original description by Ms. Platt was khaki pants. He was wearing long shorts that kind of came down
Right below
close
the
to
knee.
his knee.
Well, your name, it's on page 353 of the record.
Excuse me, Your Honor?
It's on page 353 of the record.
Yes.
It shows it. What inference do we draw from the fact that the police are questioning him 25 minutes after the shooting?
Well, the inference, well, what Officer Johnson said is that he knew that Jones frequented that park, and Jones lived about a mile away, but that was his former neighborhood. He hung out at that park, and Officer Johnson testified that he went to Maurice Jones's house to talk to Maurice Jones, and then he talked to him, he patted him down, he left, and then 10 minutes later, at Detective Lear O'Leary's direction, he went back a second time, the detectives went back, and that's when they photographed Mr. Jones. So I don't know what inference you draw other than somebody suspected him in some way of being involved.
Can we, was there at any point that the passenger, the driver who survived, the girlfriend?
Platt, yes, Your Honor.
Platt, did she at any point ever see the photograph that the officer had taken?
She was, there's no evidence that she was ever shown a photograph of Jones, a photograph of his shirt, a photograph of his shoes, anything.
At any point?
At any point, including pre-trial, at trial. They did not attempt any kind of identification procedure.
But this was an
with her.
exhibit, these were things that were exhibits at trial, photographs of Mr. Jones that were taken.
The photographs were introduced at trial, yes, Your Honor.
Okay, but she was not shown them at trial.
Not while she was on the witness stand, no, Your Honor. Not on direct or on cross. They did not attempt any identification procedure with her at all.
And I don't know what a Chuck Taylors look like. So if I'm looking at these shoes on page 354, which are completely black, and I think they're Nikes, are
Yeah,
they?
those are black, the testimony was that those are black Nikes, Your Honor. Several police officers testified he was not wearing Chuck Taylors, he was wearing Nikes. The testimony from Ms. Platt was that Chuck Taylors, they have like a distinctive white rubber front.
I've
The
seen
shoe is
those, yes,
black,
yeah.
the front
Right.
is distinctive white, and there's a white stripe. That's how she described them in her pretrial, in her statements at the hospital, and in her trial testimony. And she was sure that the person she saw walking away from her car was wearing Chuck Taylor Converse shoes. So so the only other element of their case, I submit, other than mere presence, is consciousness of guilt.
Was there, in terms of the investigation, and I appreciate that the police went to find Mr. Jones at 25 minutes later. Anybody else was he the only suspect all the time?
Well, the police officer testified he was interested in Jones and several of Jones's friends. There was also evidence that they did encounter somebody near the park who they questioned, who was wearing a white T-shirt and khaki pants.
And there was no evidence of any connection whatsoever between the defendant and the victim?
Absolutely not, Your Honor. I mean, I had the same question that I guess that both Your Honor and Chief Justice Gantz have asked, which is basically, why do they go to this guy's house 25 minutes later, other than some police officer had a hunch? I mean, that's based on the record. That's all I can surmise. There's really nothing else. He was somebody who was known to the police, and he was someone who frequented the area, and they went to check him out. But there was zero evidence of any motive, zero evidence of any connection between Jones and either of the shooting victims, and that's completely missing from their case, as is any forensic evidence connecting Jones to this shooting, as is any evidence that Jones ever had a weapon or access to a weapon. There's none of that.
When they spoke to him in 25 minutes, and they went away and came back, I can't remember what then happened, but was there any testing for gunpowder residue?
No,
or-
the officer, O'Leary, when he questioned Jones on the second visit, asked him if he was willing to have his hands tested for gunpowder residue, and Jones put out his hands to do it, and O'Leary
This
testified.
was still at his house?
He
Or
was outside his house.
Outside his house?
But O'Leary testified he had no intention of doing it. He was only asking him that question basically as he asked about the
About
show
the-
up to basically
See what his reaction was.
to gauge a response. So that there was no testing actually done of Jones's hands or anything else.
And
which
when
would-
was he arrested?
I'm sorry, Your Honor?
When was he arrested, sorry?
When was he arrested?
Was
I
it that
don't-
day?
I don't know the answer to that question, Your Honor. I'm sorry. I think he was arrested much later. He was not. I don't believe he was arrested that day, but I'm not sure. If the Commonwealth doesn't have the answer to that question, I'll be happy to provide it in a letter. I wasn't ready for that question. I'm sorry. So they have mere presence. They have conscience of guilt because there was evidence that Jones lied to the police when he said he'd been home all that day.
So on the mere presence,
Yeah.
because one of your arguments relates to the non-giving of that instruction. Was it asked for?
No, it wasn't asked for, Your Honor. It was not asked for.
But isn't it I guess I thought it was a sort of standard piece of the instruction on joint venture
It
or
is.
whatever else.
It's a standard piece of the instruction on joint venture under the model homicide instructions.
And that was what was given? Was it a joint venture
No, Your
instruction?
Honor, it was not a joint venture. I guess what I was suggesting in that argument is that in a case where there is evidence of presence and yet there's
I see, yeah.
there may be reason to doubt
So
the
it's-
connection between the defendant and the crime, that the judge should give that instruction in any case, whether it's a joint venture case or not a joint venture case. But it was not asked for. And so I guess my suggestion is that the judge should have given that instruction sua sponte.
If we can turn to the so-called refusal
Yes, Your Honor.
evidence. You had described in your brief an explanation by the police officer as to why he asked him to do that. Was that in the offered at trial?
The explanation?
Yeah, that I
Want to gauge his
that I just
reaction?
wanted to gauge
Yes,
his
that's
reaction.
exactly what he said. He said he was asked, O'Leary was, Johnson originally said on direct exam, it first came out through Officer Johnson. He said on direct that he was asked about going to the hospital. It was kind of just a vague reference. That was not at all sort of picked up on cross, but then on redirect, he was specifically asked by the prosecutor, that is Johnson, about what Jones was asked about going to the hospital, and Johnson testified he refused to go to the hospital to be shown to Platt. Then O'Leary, Detective O'Leary, on direct examination, there's a series of questions where he's asked to explain, yes, he did ask Jones about going to the hospital. He had no intention of actually bringing Jones to the hospital. The reason he asked that question was to gauge his reaction. I'm paraphrasing, but that's in that series of questions and answers, that's what O'Leary says on direct. So basically, the jury hears the explanation, which is pretty clearly it's a consciousness of guilt explanation. He's being accused of being a perpetrator, and he's refusing to be shown to the surviving victim. A fair inference from that, under consciousness of guilt, is that he's guilty and doesn't want the survivor to have a chance to identify him.
Was there a consciousness of guilt instruction given?
There was a consciousness of guilt instruction, which did not refer, of course, to the refusal evidence. So I'm not saying there was error in the consciousness of guilt instruction that was given. The error was in the Commonwealth's deliberately eliciting this refusal evidence, which, under the rulings of this court, it's been unconstitutional since 1992
But
to elicit refusal
is there a
evidence.
difference between, if he had gone and, let's say, she had identified him, that's Ms. Platt furnishing evidence. In Conkey, which was my error, and the other cases, it's actually the defendant affirmatively giving the evidence,
That's
whether
right.
it's the sneakers or it's the breathalyzer or whatever. I mean, so
Hinckley,
there,
Leiden, right.
Yeah.
This court has explained that it's basically because it's evidence about the defendant's state of mind. The defendant is basically making a voluntary decision. Should I do this or shouldn't I do this? And that thought process is testimonial.
isn't it a Fifth Amendment Article 12 issue?
It is.
Yeah, so,
It's an Article
but
12
in other
issue.
words, it's, the problem with requiring them to do it is potentially furnishing evidence, right?
Exactly. It gives him a catch-22. He can either agree to do the test and therefore potentially incriminate himself, or he can refuse, and if that refusal is used against him, that is burdening the exercise of his constitutional right to refuse. That's why it's an Article 12 violation. That's what this court has said since the opinion of the justices in 1992, consistently all the way through the present. It was clearly a constitutional violation. The Commonwealth's arguments that somehow the door was open to this because defense counsel on cross of Johnson established that Jones was polite and respectful and spoke to the police is ludicrous. And their other suggestion that the door was open to this refusal evidence because of what they call a percolating Bowdoin defense is equally ludicrous. There was no Bowdoin defense presented at trial. And in any event, this was not proper police procedures. This was a ruse to try to elicit conscience of guilt evidence from the defendant. And they got their refusal. They deliberately introduced it at trial twice through two different witnesses, and then they exploited it in closing argument. And if this court uses the Mahdi factors, which I submit are really the right factors to look at in deciding whether this is reversible error, the defense wins on all five. This went to the heart of the defense. That is, the defense was he wasn't the perpetrator, and this was evidence suggesting he was the perpetrator because he was afraid to be shown to the surviving victim. It was introduced by the Commonwealth. That's the second factor. Who introduced it? This was a weak case. That's the third factor, the strength of the case. It was introduced repeatedly and exploited in closing. That's the fourth factor. And there was no curative instruction given by the judge. The judge didn't limit it. She didn't strike it. She didn't do anything. It came in for all purposes. That's the fifth factor. So under the five Mahdi factors, This is reversible error. This court in Letkowski last year reaffirmed what they said in Mahdi, which is a Mahdi violation. Reversal is the norm, not the exception. This should be treated just like a Mahdi violation. It's the same violation of Article 12. It's the same violation of the defendant's right against compulsory self-incrimination. So I submit to the court that the case should be reversed based on insufficiency of the evidence, but if the court does not agree that the evidence was constitutionally insufficient, clearly the case should be reversed and remanded for a new trial at the very least. Thank you.
Two fast questions before you sit down. Was the so-called refusal evidence offered at the first trial?
I believe it was, Your Honor. I believe it was offered.
But your brief says it wasn't.
I'm sorry?
Your brief says it wasn't
No,
offered.
what wasn't
and you-
offered the first trial, I think, was there was a recording that was introduced at the second trial, but not the first trial. Whatever my brief says, I will rest on my brief because I had read the first transcript. I did not reread it prior to this oral argument. But whatever's in my brief, I will stand on what's in the brief. But my recollection.
I think you said
Yeah.
that you were pointing that out to say that there was a difference between what happened at the first trial and what happened at the second trial. You were offering that as a possible, to show how important you thought that was.
Well, I think the difference, Your Honor, is that there was a tape, a police tape by Lee, which of a description of the T-shirt, which came into the second trial, which had not come into the first trial. I don't think it was a refusal evidence.
Okay,
But
all right.
clearly, the Commonwealth is wrong when it says the refusal evidence was insignificant, inconsequential, minimal. It was none of those things. It was devastating. And defense counsel tried to deal with it. He tried to deal with it in his closing, but he really didn't deal with it effectively because there was really nothing he could say.
And with regard to the peremptories, which you didn't have time to get into, am I correct that the Commonwealth had struck 5 of the 6 black jurors?
Yes, Your Honor. At the time that they struck Juror 143, they had struck 5 of 6, and
And the only difference was that at the time that this juror came up, that Judge Giles recognized that there was one black juror seated.
correct.
She
And she
hadn't-
used that as dispositive, and both this court and the Supreme Court have said you got to look at all the circumstances, and the First Circuit specifically in Sanchez said that's not dispositive. That's a factor, but what they said in Sanchez is if you allow that to be the test, then that basically gives prosecutors a license to discriminate against lots of African Americans as long as they don't discriminate against all African Americans or any other group, and that's clearly not what the Constitution allows.
All right, thank you.
Thank the court.
Mr. Sears, good morning.
Good morning, Your Honors. May it please the Court, Matt Sears on behalf of the Commonwealth. With me today is Assistant District Attorney Julie Higgins, the trial prosecutor on this case. I would also like to acknowledge the presence of the victim, Denoris Alston's family, in the courtroom today. I'll start with the sufficiency evidence where my brother started. This is a strong circumstantial case where 10 witnesses testified to overlapping fields of view following a single person, one person alone, on his unbroken path of flight from the shooting at the victim's car to his identification as Maurice Jones in the middle of the park, as again he ran by himself, alone, clutching at his stomach area, and beyond to his escape down Langford Street.
When you say a unbroken path, so I'm assuming you mean temporally. So does it start with the 3 who recognize them, or him, and don't see something in his pocket, or what's the order?
The order chronologically, Justice Botsford, is first Miss Platt. And here are 3 bits of evidence that came in regarding one individual shooting into her car. First, the 911 call. The shooter was on the street. I don't know what he looks like. He just took off. Second, what she told Bianchetto immediately after the shooting when she arrived at the gas station. As she was sitting in her car on Dunreath, a black male walked up and shot into her vehicle. She then gave a description consistent with what the defendant was found wearing 30 minutes later. Third, the first report...
Khaki pants,
white
cut.
shirt, khaki pants, black hat. first recorded interview with Detective Lee. We're just talking, then someone came up. He had a white shirt on and khaki shorts, and he had a hat on, and he just came up and started shooting. That's one person by the car. Byron Winbush at 238 Warren Street from the 5th floor looked out where he heard gunshots and saw one person. He was right there. That's in Exhibit 15 and 94. There was no one around him. He was running up Dunreath Street. Moving up and along Dunreath Street, across the street from where the shooting was at 18 Dunreath Street, Leonore Woodson and Leila Jackson hear gunshots. They look immediately across the street. Leonore Woodson observed a car leaving fast and the person connected to the car running away. One person. He was alone on the sidewalk. There was no one with him. He was galloping up to the entrance to the park on Dunreath Street, through the park, out onto Copeland, and turning left. Her description is consistent with all of the other descriptions: black male, white shirt, khaki pants.
Did anybody describe the person as having red on the T-shirt? Any of these people say anything about a red?
Ms. Platt testified at trial that he had red in his T-shirt. These people don't. These people are catching fleeting glances of him as he runs away.
Well, did she, I thought the evidence was that she only saw the person running away from the car.
She saw him standing to the right through the shattered glass as he shot into the car.
Then I
Defense
thought,
counsel-
isn't he the person that she saw walking lackadaisically?
Walking lackadaisically away from her, not responding to her screams, which she found was odd. And that's before she shifted her car into drive and drove away. And I think this is, the driving away of the car is important because inferentially it triggers the defendant's flight. Again, Leonore Woodson sees the car going out fast and then the man running. I would...
She and Jackson see the man as light-skinned?
As a black male. I don't know specifically what shade he was, but there's...
I'm not asking what shade he was. What they said is what I'm asking.
Well, I don't recall what they said, but they said he was a black male. That was their testimony. I would point the court specifically to Brian Santiago and Jerome Baker because they connect the dots. Brian Santiago is in the middle of the park. I saw the car, then I saw the person. It's one person. Again, this is important. He saw one person. He saw the man on the side of Dunreath by himself running. There was no other person that joined him. The only person who ran through the park was this man holding his pocket. Everyone else basically stood there and watched him run through the park. This is consistent with Jerome Baker, and Jerome Baker is important because he knows the defendant. He identifies him as the defendant, as Maurice Jones. No one was with the defendant as he was running through the park. No one else was with him running through the park.
Is Jerome Baker the next one chronologically after Brian Santiago?
Brian Santiago, Nicholas Guerrero, and then, yes, Jerome Baker is at 37 Copeland Street across the park. I mean, Joy Andrews and Joan Andrews are at 30 Copeland. They're in there somewhere. But the importance of Jerome Baker is that he hears shots on Dunreath Street. He sees a silver or gray car immediately speed up Dunreath Street. Then he sees Mo running through the park. So again, we have one person consistently running through the park. Tracking back a little bit to Woodson and Jackson, they describe, again, this one person who's wearing cargo shorts clutching at his cargo shorts as if there was something heavy in there, and to Miss Jackson, it appeared to her as if it were consistent with a firearm. This is consistent with Brian Santiago, Nicholas Guerrero, and Joan Andrews.
But is Mr. Sultan right that of the three people who knew him, none saw him holding his pocket as if to hold a gun?
Jerome Baker saw him holding his stomach.
And what inference do you think we should draw from that?
That he was holding somewhere around his midsection or his pants pocket that were his cargo pants pocket that was
Holding his stomach as though he were hurt. I take it that's not holding something, it's holding onto his stomach.
well. It is testimony that he was holding something with his hand. It is testimony that connects the defendant, who is Maurice Jones, to the same person, the singular person who 4 witnesses testify was clutching at his side pocket that was swinging wildly with a heavy object in it as if it were something that was important to him, and something that was potentially a gun. So we have all of these connections, and we have Brian McLean later on, who affirms that Maurice Jones was walking down Langford Park toward the hole in Perrin Street, the hole that led from Langford Park to Perrin Street and from Perrin Street to Warren, Waverly and Warren. This is not a mosaic, it's a tapestry. All of these visions weave together. And the most important thing to focus on is that there is one person. We have consistent testimony about what the one person was wearing. The one person, his clothes were consistent with Maurice Jones's clothes as...
Excuse me, does anyone make any observations about the shoes that the man that they saw running was wearing?
I believe
Ms.
all...
Platt talks about it as being, what was the name of that?
Chuck Taylor.
Chuck Taylors, which I don't know what they look like, but.
So Chuck Taylors are all black. They're high-top
Taylors are
all black shoes.
He doesn't describe them as all black.
Well, they've got white fronts.
It's at the very bottom of the sole they have white, and they have white fronts. But I mean, his shoes are also...
Well, is it on the sole, or does it cover the toe area?
It covers the toe area. His shoes are also...
We'll get you a picture of some Chuck
No, but I
Taylors.
mean, it's
Chuck
different to
Taylors
say
don't
it's
have
the
to be all
sole
black. Let's
versus
just
it's on the
make it
top.
clear.
I mean, it really is.
I think the way Ms. Platt described them was all black Chuck Taylors. In any event, his shoes were all black, and he had short white ankle socks.
That's what he was that's what the defendant was in fact wearing.
That's what he was in fact wearing. I think-
Is there any indication that those were Chuck Taylors that he was in fact wearing?
No,
Wearing
the
Nike-
indication is
he
that
was
they were
Wearing
Nikes.
Nikes, right?
Yes.
And so you're saying that they look the same as the Chuck Taylors?
I'm saying it's not wildly inconsistent with what he was wearing. I think that he was
Have
certainly
army boots
wearing...
on. Yeah, I give you that, but, I
Well,
mean,
they
if
were
she's
both
very
black.
sure that they're Chuck Taylors, and Chuck Taylors has white on the front, I don't,
And so the question is, these people you're saying that form part of the tapestry of observers, what did they observe about the shoes, if anything?
Nothing that I can recollect. But the point is that they consistently saw one person. They saw no one else than one person. Their description of him was not wildly varying in what he wore, what his race was. It was, in contrast, very consistent. It was white shirt, cargo
It would
shorts,
be,
black
it would
hat.
be very distinct, a distinct observation if a person is running through the park wearing Chuck Taylors. I mean, that's the kind of thing somebody would notice, and you would expect some of the people who saw this person running to say that.
I think in the aftermath of a shooting, where people are trying to figure out what's going on, and all they ever see is one person running, a single person, it doesn't really matter the specific description of his shoes.
No, I understand, but I'm just trying to assess the importance of the victim's testimony that she was sure. She wasn't sure of much else, but she was sure that this person was wearing Chuck Taylors. And they described the pants. You know, cargo pants are different from other kinds of pants, and I'm just trying to figure out what that means.
Cargo pants are certainly different, and they're distinctive, and she was sure about the cargo pants, as was every other witness. The one thing that ties the description together was that they were cargo pants. They were khaki or brown cargo pants, and that the side was swinging with something heavy inside of it. Consistent also was a white T-shirt and a black hat. Those are all pieces of consistent evidence that these people saw. And I think what we have here is not just this action incident. We have bookends. We have the defendant's presence in the area, but not just his presence, his familiarity with the area and his specific knowledge of the immediate neighborhood. Both his mother and his sister said he grew up there. Jerome Baker says he saw him 3 times in the area. McLean knew him as Mo from Copeland Street. Joy Andrews said that he was around the neighborhood every single day. Johnson and Fanning testify that that's where he hangs out.
Doesn't he live in the area?
He doesn't. He lives about a mile away, 18-minute walk according to Johnson, 15-minute walk according to his girlfriend.
Can I ask you, did Ms. Platt at any point identify the defendant as the shooter?
She did not, but she also testified that she didn't see his face, and she only saw what he looked like through the shattered glass outside of the vehicle.
Ever shown a picture of his clothing?
Not that I know of, not that the record reflects.
That's odd, don't you think?
I don't know. I'm not going to read into it whether I think it's odd, and I don't think that it matters for sufficiency of the evidence review, where this court will consider the light most the evidence in the light most favorable to the Commonwealth and all inferences in the Commonwealth's favor. The other side of the bookend is the defendant's consciousness of guilt evidence. We have flight, but more specifically, we have a false alibi where he tells officers he was home all day. That's specifically contradicted by 3 eyewitnesses and by the CSLI evidence. There were specific lies about him not being at the park. Again, that's contradicted by evidence from 3 witnesses. That he was outside to meet his mother when officers came upon him. His mother came and told officers, "I had no plans of meeting Maurice Jones," and that his dominant hand was his left hand when later on he signed a document with his right hand, the same right hand that inferably was clutching at the right side of his body as he ran through the park. He was excitable, anxious, and nervous. I'm not saying that's a dispositive characteristic for consciousness of guilt, but it adds to the mosaic. And finally, this admission. Your Honors asked when he was arrested. I think he was arrested about a year later. But Jerome Baker said, after seeing him for about 3 times per week in the area, he didn't see him for months afterwards. When he finally did see him in the Dudley area, the defendant told him, "The block is hot and there's cops everywhere." This is fairly inferable as an admission. I don't have a ton of time.
Yeah, why is that? I mean,
well-
the police are interviewing him the night before the shooting. They're interviewing him half an hour after the shooting. There was a shooting. I assume the police are trying to solve it. Why does the fact that the block is hot mean that says that I did it?
Well, it explains why he wasn't in the area for months after the shooting, and he had been in the area for 3 times per week leading up to the shooting. It explains the significant difference in his visitation of the area where he grew up and where he frequented before. It's an inference, it's a permissible one, and considering all the evidence together, it's one that the jury could infer guilt. I want to move, because I don't have a ton of time, to refusal evidence. Where the bottom line for refusal evidence is where refusal evidence is admitted solely to reflect or infer the defendant's state of mind, his communicative thought process, then there is error. I agree to that 100%. But when refusal evidence is admitted for some other purpose, this court, the appeals court, the federal court has found over and over again that it's not improper, such as...
It was like a hammer being used to kill a fly.
It wasn't, and it wasn't a hammer for 3 reasons. One, it could have been a hammer if in opening statement the prosecutor had mentioned it at all. She didn't. Could have been a hammer if during direct examination of Officer Johnson the prosecutor had specifically elicited it. She didn't. It could have been a hammer if when Officer Johnson, in a vaguely non-responsive way, mentioned GSR testing and going to the hospital. She didn't even follow up on that question. I disagree entirely with my brother, and I'll point the...
Well, I mean hammer in the sense of the weight of that kind of evidence in the whole scheme of things. I mean, that's pretty damaging.
And the whole scheme of things is important because we're talking about the context in which this evidence was admitted. The context was, my brother said earlier that there was a vague reference on cross-examination, or a vague reference by Johnson, not at all picked up on cross. That's entirely inaccurate. And I would point the court's attention to Volume 3, page 77 through 79. The reason the prosecutor admitted this refusal evidence was in direct contrast to rebut the misimpression left by Attorney Howard on cross of Johnson. Attorney Howard goes straight in and he says, "Oh, so you say that there was GSR test offered to Maurice Jones?" Johnson says, "Yes." The officer says, well, defense counsel says, "Did he offer to take it?" And Johnson says, "Yes." And he made this GSR testing a cornerstone of his defense. During closing argument, he argued to the jury...
Wait. I mean, defense counsel elicits that the individual appeared to be cooperative. Does that then trigger the inquiry to say, when you spoke with him, did he invoke his right to silence?
It's more
to show that he was not being entirely cooperative?
It's more than just cooperation. It's cooperation plus obliging, ready to oblige at every turn, plus eager to prove his innocence. That's the line of questioning that defense counsel asked Johnson on cross-examination. In that entire context, where he had to rebut damaging consciousness of guilt evidence that was admissible, he brought out some consciousness of innocence. And the Commonwealth was entirely permitted, it was not impermissible and it was not impertinent, to combat and rebut that misimpression. He was not always obliging.
Where do you go with this? An OUI case, if the person appears cooperative with the police, did you say, did he agree to a breathalyzer? No, and then you argue that he was not as cooperative as he said he was?
It's not just cooperation, it's willingness, eagerness to oblige and to prove innocence. And that's what the GSR testing
So on
would
that score, you could say he refused to talk to us? Chief Justice Gant's other question?
No, I think if the defense counsel made it an issue and said he did all of these other things, then perhaps it could be, yes. And that's
Think
that's
that
the
would be
case law.
fine? That would be fine? To say, we asked him, did he want to make a statement, and he refused?
In the context of the defendant did every single thing in his power to cooperate and prove his innocence, yes, it's permissible. And there's case law to support that. I would cite Johnson again. Using refusal evidence to correct any misimpression created by the defendant's direct testimony was neither impertinent nor improper. Habarak, that didn't make my cut because I cut down and I accidentally cut it out. 402 Mass at 105, 110. That's a Doyle error, right to remain silent. The officer's testimony on redirect examination was properly admitted in response to inferences left by defense counsel. Broom, Beaulieu, O'Laughlin, this is a consistent line of cases that says it could be permissible in these circumstances. I think the point is that this evidence was in those circumstances. It wasn't just to show that the defendant had a guilty conscience.
So
and it wasn't used that way.
what do you think the reasonable inference of a juror? Well, let me ask you this: it was argued in closing?
I don't agree that it was argued directly in closing. It was mentioned.
What did she? Well, okay. What did she say in closing?
She just said it. And
Said what? That he.
and he declined to go to the hospital.
Okay. And what inference is a jury going to take from that? If
Right.
apart from the fact that he was worried that if he did go, she would identify him.
When they're not specifically instructed, the inference is no inference. And I think that's the difference between the cases. In Vermette, harmless beyond a reasonable doubt, Delaney, those cases stand for the proposition that where there's a proper consciousness of guilt instruction that does not encompass refusal evidence, but other more damaging consciousness of guilt instruction, the error is not prejudicial. And that's what distinguishes it from Leiden, from Hinckley, those cases where there is a specific instruction that the jury can consider that refusal evidence as consciousness of guilt evidence. This, again, was a strong circumstantial case. It was not exploited. There were 4 officers there. Fanning and O'Leary were also there. The prosecutor did not bring out on examination of them that they overheard this refusal evidence, and again, the instruction encompassed other consciousness of guilt. Reversal is warranted perhaps where there's an objection. There was no objection here. Defense counsel took this as part and parcel of his defense. Where there's no other reason for the admission, that's not the case, and where a judge instructs on consciousness of guilt, that's not the case. And if your court will indulge me on the peremptories just momentarily, the numbers is a distortion. The numbers 5 out of 6 is not reflected in the record. The record shows that the Commonwealth was content with 8 people or 9 people at the time of 143 that the defendant struck, and there's no indication of their race. The judge made what was a permissible factor. She made permissible findings on the record that this court has approved in ISA, that this court has approved in Fryer.
But could I ask you, though, I didn't see you addressing Sanchez. Maybe you did and I missed it.
Well,
but
I don't see that Sanchez is necessarily applicable in this case. Sanchez is very fact specific, and this brings me to what a defendant has to do. A defendant has to make a showing, some showing. The defendant.
But we're not on a clean slate here, because the judge had found that there was, before we got to this juror, the judge had found that there was a pattern.
She did, but then there were, I think, 5 other Commonwealth decisions after that pattern. Every time there's a source challenge, especially when a defendant just says source twice, as what happened here, there has to be a new analysis, a new assessment. I'm not saying you forget a pattern that you found before, but you would also take into consideration that 113, the judge found, was not a racially based challenge, that there was another juror who was sat at 117, and again, this court has found that that's relevant to the considerations. I don't think that she found that there was a pattern, and pattern is not dispositive. The defendant acts as though pattern is dispositive, but that's not the case. There's no per se rule, and there's still that second prong that the defendant has to meet, that it was, the strike was likely lodged because of membership in this group pattern. And just one final thing on the showing here. This court in Commonwealth versus Scott talked about the insufficient showing. Scott versus Gelb was the First Circuit Court case that approved this court's treatment, where it was just an insufficient showing by defense counsel, where he said soars, he didn't make much of a challenge. The judge here did what she could do. She saw the veneering. Impanelment occurred all in one day. She saw the manner of the questions by the prosecutor. She heard the explanations and the answers to those questions from the prospective jurors.
But
She
just
was
quickly,
there.
let me ask you if you think that the judge was correct to say that this is not a problem because we've got one juror, one black juror in the box.
I don't know that she said that this is not a problem. She
Well,
said
I'm
we're in a different position.
paraphrasing.
Well, I think it's an important distinction to make. She says we're in a different position. Whatever position we were in at 113B, we're not there any longer. Where we are now, we have a Commonwealth not challenging a member of a discrete group. We have, from her perspective, a challenge lodged that was not race-based, that was neutral. And from her point of view, those factors do not indicate a likelihood of a challenge.
She doesn't go on and on like that.
She doesn't have to, because
I
she's
mean,
there
but,
on the ground.
You're reading a lot into what she said. I mean, she basically said, well, now we've got a black juror.
I don't think it's that
I don't think
simple.
it's maybe that simple, but it's not like you're representing that it is, as far as I can see from the reading of what Judge Giles had to say.
Well, I think, again, this court grants great deference, and this court will not overturn the judge's ruling if there's a sound basis in the record. So we have to look at the record. We have to look at everything that's gone on in the record. We have to look at the fact that Judge Giles, not the defendant, was the one who mentioned at 113B if there was a pattern or how many strikes of whomever discrete group there was. Judge Giles was keenly aware of whatever pattern existed, whoever was left in the veneering, what the questions were, what the explanations for the questions were. And one final thought on Sanchez, because I'm answering your question right now, just as like, Sanchez was an issue where the court looked and said, okay, there are similarly situated white jurors who made it into the jury and who were not struck, and we're going to consider whether or not the presumption was rebutted because of that. There's no similarly situated juror in this case who had education from outside of the United States, who worked alone, who had sat on a jury before, who made it into the jury. That would be the great distinction in Sanchez, and that's why I don't think Sanchez is appropriate at all.
I'm sorry, education outside the United States and having served on a jury is an appropriate basis to strike somebody
I'm not saying it's an
without...
appropriate basis. I'm saying those are factors that this juror had that no other jurors had who were sat on the jury.
But the thing is, the judge didn't even get to the explanation stage, so it's not as if we can say she asked for an explanation and it was given and she was satisfied.
The problem with the explanation state is that, again, the reason we grant discretion to the judge is because she sees everything that goes before her. Just because she doesn't say it doesn't mean that she didn't see it. This court at times has conducted de novo review on the rebutting of the presumption of propriety. Other courts have. I'm just sort of pointing that out in case it gets to that level. I don't think it should. I don't think it needs to. And I think that this record fairly and accurately supports the judge's decision.
And is there any consequence that in 2010 in Issa we said judges should think long and hard before they reject a claim of prima facie and invite an explanation, because if you're wrong, it puts us in a very difficult position with regard to reversal?
I think it's great advice. I don't think it necessarily, I mean, this is the problem with transcripts. We don't know how long and fast the judge thought. We don't know how at the bench her notepad was outlined with her considerations. We don't know if it took her 5 minutes or 5 seconds to make this determination. I think that that's accurate. That's reflective of both Batson and Soares to take a long and hard look. But where there's a completely insufficient showing on the record, and where that's the defendant's burden, and where the judge has made her own assessment of the record, including the absence of a cross-racial crime. She noted that at the very beginning of this entire trial. We can assume that she was keenly aware of all issues present here. And again, Your Honor's made a suggestion that you would agree with the defendant's numbers. They're incorrect, those numbers. They're not supported by the record. You can't read into the record that 5 of 6 black jurors were struck. There are 9 other people who the Commonwealth was content with, who were deemed indifferent by the judge. There's no record of their race or ethnicity. It's a distortion of the record. I mean, it helps the defendant, of course, for him to distort it in that way, but it's not supported by the record.
Okay, thank you.